Get ready. Exercise number 25. Start. The obvious basis of the principle against retrospectively is the principle of fairness, which must be the basis of every legal rule, as was observed in the discussion. Stop. Thus, legislations which modified accrued rights or which improve obligations or improve new duties or attach a new disability have to be treated as prospective unless the legislative intent is clearly to give the enactment a retrospective effect. Unless the legislation is for purpose of supplying an obvious omission in a former legislation or to explain a former legislation. Stop. We need to note the corpus of case law available on the subject because aforesaid legal position clearly emerges from the various discussions, and this legal position was conceded by the counsel for the parties. Stop. In any case, we shall refer to few judgments containing these dicta a little later. Stop. We would also like to point out, for the sake of completeness, with where a benefit is conferred by legislation, the rule against a retrospective construction is different. Stop. If legislation confers a benefit on some persons but without inflicting a corresponding detriment on some other person or on the public generally, and were to confer such benefit appears to have been the legislator object, then the presumption would be that such a legislation giving it a purpose construction would warrant it to be given a retrospective effect. Stop. This exactly is the justification to treat procedural provisions as retrospective. Stop. In Government of Haryana and others versus Indian Tobacco Association 2005, the doctrine of fairness was held to be relevant factor to construe a statute conferring a benefit in the context of it to be given a retrospective operation. Stop. The same doctrine of fairness to hold that a statute was retrospective in nature was applied in the case of Vijay versus State of Maharashtra and others. Stop. It was held that where a law is enacted for the benefit of community as a whole, even in the absence of a provision, the statute may be held to be retrospective in nature. Stop. However, we are confronted with any such situation here. Stop. The Honorable Supreme Court, in a judgment titled as Sri Shankaracharya University of Sanskrit Rishikesh versus Dr. Mannu 2023. Stop. It is treat that any legislation or instrument having the force of law which is clarifactory or explanatory in nature and purport, such seeks to clear doubts or correct an obvious omission in a statute, would generally be retrospective in operation. Wide. Ramesh Prasad Verma, stop. Therefore, in order to determine whether the government order dated 29th March 2001 may be made applicable retrospectively, it is necessary to consider whether the said order was a clarification or a substantive amendment. Stop. If a statute is curative or merely clarificatory of the provision law, retrospective operation thereof may be permitted. Stop. In order for a subsequent order to be considered as clarificatory of the previous law, the pre-amended law ought to have been vague or ambiguous. Stop. If it is only when it would be impossible to reasonably interpret a provision unless an amendment is read into it. Stop.